Hello and welcome to Quadcast, Quadrant Chambers' weekly discussion programme looking at news, hot topics and legal developments in the world of commercial litigation. We have four barristers from Quadrant Chambers in London. That's me, Paul Downs. Emily Saunderson is filling in this week for Poonam, and we have Claudia Wilmot-Smith as usual and Joe Sullivan. So hi everybody, welcome back. Let's do some news and catch up. Who should we start with? Emily, welcome back. What's your news?
So I'm going to apologise in advance for the slight rubbishness of my news. That I finally caved in and bought a second screen for my work computer. I'd mainly been holding off actually because Paul had said you definitely need a second screen, and I thought no, as with many things that Paul says, that can't possibly be right. But I have caved in this week and bought a second screen, and I've spent most of the week trying to resist the urge to pick up my phone and scream, buy, sell. So that's my news.
You are right, that's very dull. And about a year too late as well. So, yeah, Joe, what's your news?
Well, as you'll know, Paul, today is World Book Day. So,
of course,
my daughter went to school dressed as Peppa Pig, who is in some books, although primarily a TV character. And I've been reading The White Book today, which is an absolute belter. Like Bravo 2.0. But
you've also
improves with each read.
But you've dressed as Where's Wally, haven't you, as well?
What?
Nowhere near Paul.
Isn't he red and white stripes?
With a blue hat.
I'm just glad to see you're wearing the Chelsea colours today, Joe.
Oh,
Claudia, what's your news?
I never have news. I do my vicarious news. In the theme of buying screens and virtual hearings, state congresses are sitting remotely. And I saw that a congresswoman in New Hampshire got rather reprimanded for appearing. If you can see Republican Representative Anita Burrows on the left-hand side of the screen, appears with her cat, which is like, this is my fear of my cat turning up in a court hearing. Anyway, she apparently got her cat banned from Congress. And then after the ban was reported, the leader of the House said, no, I didn't ban her. I just said that it would be better if her cat didn't appear because people might think that he was sitting in as a legislator.
So, furious, doesn't he? I don't know what
he does. Yeah, he's considering important legislation issues. Apparently, you know.
Cat. I mean, is that cat close to the camera, or is it just a very large cat on one of them?
I mean, kind of. Yeah, his head does look as large as the Congress.
Giant.
But yeah, he has now been banned from Congress. So.
Well, my news, it was not really my news, but I saw in the Times this morning, did you see this survey they've done, Judge Attitude Survey?
Yeah.
And I'm listening to the statistics on this, 55% upper tribunal judges, 44% Court of Appeal judges, and 40% circuit judges are all saying they want to retire early in the next 5 years. I mean, that's a lot, isn't it?
That's a worry.
I'm also surprised that the Court of Appeal is higher than the circuit judges, right?
Well, these circuit judges, they're loving it. They're the happiest, aren't they?
But the survey also said, didn't it, that the percentage of High Court judges thinking of retiring early has decreased.
It's gone down.
Gone down, yes.
Oh, right, okay. That's because they've all retired.
The more new High Court judges.
Well, yeah, that's right. All the ones that were very unhappy have retired.
Yeah.
Right. Okay. So we're going to look at a topic this week. Look at the without prejudice rule. Can I just say and remind you to join in if you would send us questions. You can email us your questions. I'll say that again. Email us your questions. quadcast@quadrantchambers.com. Or you can chat along in the YouTube chat function if you're signed into YouTube, if you're watching this. Well, you are all watching this on YouTube, I know. So this week we're looking at the without prejudice rule. There's been a couple of recent cases looking at the exceptions to the WP rule. And I just want to put my cards on the table right at the outset. My position is that this rule is so wrought with uncertain exceptions that you may as well, it's going too far to say you may as well not have the rule at all, but it's so easy to get around. And I know someone is going to argue, Court of Appeal recently, Hytera, it makes it all much more tough. Well, I'm going to be arguing not so if you read it, the decision carefully. But anyway, we'll start with Russian Tompkins, which is the case that we start with, which I think was rightly decided sound, but has been undermined. Claudia, tell us about Russian Tompkins.
Yeah, so Russian Tompkins was a case where the House of Lords was considering where without prejudice correspondence comes into existence for the purposes of negotiating a settlement between A and B, who do then settle, is that correspondence privileged from production as against C, who is a party to the same action? So it was originally A against B and C. C was not a party to the settlement agreement. A's action continues. Can A get this? Can C get this WP correspondence? And the House of Lords considered the whole matter to be about public policy and considered the public policy behind the without prejudice rule. There had been this idea that the without prejudice rule protects statements made during the course of settlement negotiations. If those negotiations culminate in a settlement, then the purpose of the rule has been fulfilled, basically, because it's all about encouraging settlement. The privilege has been exhausted, and A and B had here settled. So C said, well, we can get the correspondence. The House of Lords said no. Lord Griffiths gave the lead judgment, thought that this tripartite situation was a novel point, but could all be considered by considering the basic public policy motivations behind the rule. He said, we are here to, it's designed to encourage a cards on the table approach to litigation. The case before the House was in no means unusual, right? But it's often the case that disputes between two parties are part of a overall bigger dispute, which involves lots of different parties. And if B makes concessions or says things to A during the course of negotiations in order to encourage settlement, and thinks those statements, concessions, etc., will be admissible, then they might be less likely to say them. But the fact that that has settled doesn't mean that those statements should be admissible. You would be equally reluctant if I say things because I'm negotiating with Paul a dispute, and I say things like, "Yeah, actually, I did, hit Emily in the face so she couldn't appear as your junior in court," and because I accept that, we settle. I'd be less likely to say that if I think he could then just disclose that to Emily, right? So the House of Lords says it isn't exhausted by settlement. That doesn't get rid of the purpose. And so the general rule is the without prejudice rule renders inadmissible in any subsequent litigation connected with the same subject matter proof of omissions made in a genuine attempt to settlement, whether or not settlement has been reached, and whoever is trying to seek disclosure of the issues.
So the point is that you have to have this very strict rule, because otherwise no one's going to be frank and open at the proverbial mediation. That's the point, isn't it?
Exactly. Right. And that's as true whether or not I'm concerned about not settling and you therefore later relying on my settlements in court, as whether or not we do settle but somebody else would rely on the same settlements in court.
But there's a whole list of exceptions. And Joe, I mean, the leading case, Unilever, yeah?
Yeah, Unilever. It was a patent case. So Procter & Gamble had a patent about a washing machine process. But there was a number of disputes about this patent. A German company called Henkel challenged the patent in the European Patent Office. And there was also a Unilever product, a Persil product, which was said to infringe the patent. Anyway, this all led to a meeting in Frankfurt that was expressly without prejudice, where a number of different parties all got together. And in the course of that meeting, someone from Procter & Gamble said to someone from Unilever, if we don't sort all this out, then we've got this patent and we think you're breaching it, so we might bring infringement proceedings. Unilever then brought a claim in England under Section 70 of the Patent Act, which is a cause of action which is based on threatening to bring infringement proceedings in certain circumstances. And Procter & Gamble said you can't do that because the threat that you rely on was made without prejudice at this without prejudice meeting. So those are the facts. Emily, what happened?
So Unilever is the case that you go to if you want to find an exception. Lord Justice Robert Walker set out a non-exhaustive list of 8 exceptions, so times when you can bring in without prejudice negotiations into evidence. So firstly, where there's an issue as to whether the without prejudice communications have resulted in a concluded settlement, you can bring in without prejudice negotiations evidence of those to show whether there's been a settlement. Secondly, you can bring in those negotiations or evidence of them to show that an apparently concluded agreement has been should be set aside because of misrepresentation, fraud, or undue influence. Thirdly, you can bring evidence of WP negotiations in to show or support an estoppel. So where there's been a clear statement made by one party to the other, where there's an intention the other party would act on it and they have acted on it, you can bring in evidence of WP negotiations to show that. Importantly, for the purposes of today, there's an exception where to exclude the evidence would act as a cloak for perjury, blackmail, or other unambiguous impropriety. And that's a phrase that was used by Lord Justice Hoffman in a case called Forster and Friedland. And fifthly, you can always use it to explain delay or apparent acquiescence. So if, for example, you are late serving witness statements and you need to explain why there's this delay, and it's because you've been trying to settle with the other side, you can bring in evidence as to the fact that negotiations have been taking place with a view to settlement. And depending on the facts, it might be enough that you bring in evidence simply of the fact that negotiations have been going on, but you might need to go into more detail about what the settlement discussions actually were about, depending on the facts of the case.
Having heard that list, is that maybe a clue as to why Paul thinks that you can always seem to get round this rule?
Possibly quite long.
It is quite long.
Clients are always engaged in unambiguous impropriety.
I've got a mediation next week. So you say to your client, the client says, look, if what I say, can I speak freely? And you say, yeah, totally. It's totally without prejudice, except for here's this list. And then you get to like unambiguous impropriety. I mean, we'll talk about it. But he says, what does that mean? So, well, it's very difficult to say. It's very fact sensitive. Forster and Forster, there was mediation where you got professionals on both sides and an email sent. And Court of Appeal later says it's unambiguously improper.
Well, sorry, I think I may have been jumping the gun there.
Anyway, look, you're just teasing me. I know you're teasing me, but okay. What about, there's another exception that's very difficult to tie down, this independent fact. I mean, don't get me started on this independent fact theory.
Well, you say it's an exception, right? And Joe's already said that there's this long list of exceptions. But in Muller and Lindley and Mortimer, Lord Hoffman said, actually, everyone talks about without prejudice privilege. He said, actually, if you look at the scope of the rule, he doesn't see himself as adding an exception. He just saw himself as defining the scope of the rule in such a way that means that evidence is privileged for some purposes, but not others. So Lord Hoffman said, the rule precludes statements made during the course of negotiations from being relied upon as truth of their contents. But he says, and everyone agrees, if you look at all the cases, it doesn't render those statements inadmissible in any more general sense. So in that case, the claimant was suing his solicitors. He said that they had negligently advised him. In acting on the negligent advice, the company that had employed him had dismissed him. He'd been a shareholder in the company, and if he was dismissed, then the company got a right to buy back his shares based on their value at the time. He was dismissed by the company. They brought back his shares for about £30,000. Many years later, they were worth millions. And he sued the company, and he said, you shouldn't have dismissed me. And he sued the board of directors. Those proceedings were settled. He then sued his solicitors, saying, if you hadn't given me this piece of advice or whatever, I would never have been dismissed by the company. He also said during the course of his proceedings against his solicitors, I sued the company and the board of directors to reasonably mitigate the loss I suffered as a result of your negligence. His solicitor said we weren't negligent. Even if we were, it didn't cause any damage. But also, they said the proceedings that you brought against the company were not reasonable mitigation. And they sought disclosure of the correspondence leading up to the settlement because it's quite relevant to this mitigation issue, right? And the defendant said, no, this correspondence is all WP, so you can't look at it. Lord Justice Hoffman, as he then was, and this is quite important because it's only a Court of Appeal case, because Paul will make the point later, but I think probably that everyone ignores it. But Lord Justice Hoffman, sitting in the Court of Appeal, said, well, if you are seeking disclosure of this correspondence to rely on what had been said in the correspondence as proof that it's true or not, then you couldn't get it. It would be WP. But here, it's being sought as relevant to the issue of the reasonableness or not of the settlement. And so the public policy aspect of the rule, he says, isn't even engaged, right? So he says, if you are looking to rely on so if you are looking to get disclosure of correspondence as evidence of whether or not there has been offer and acceptance, then that's an independent fact. If you're looking to prove that a threat has been made in a WP letter, again, you're not saying whether or not it's true. If you are looking to prove that a statement which amounts to an act of bankruptcy has been made in a WP letter containing that statement, it's admissible. If you are looking to explain a delay in commencing or prosecuting litigation, it's admissible. So what Emily has talked about as exceptions, he says actually it defines the scope of the privilege. All of these things fall outside of the public policy, and therefore they're admissible, not as an exception, but because the rule isn't engaged.
So the independent fact theory is you can admit a without prejudice statement, not for the contents of the statement, but to prove the fact that the statement was made, yeah? So that means if that's right, Unilever's wrong. But the outcome is wrong on Unilever because they were not adducing the statement for the truth of its contents, they were reducing it for the fact that the threat had been made. So straight away, you've got two Court of Appeal decisions you can't reconcile. Emily, do you agree?
I do, but doesn't I'm not sure that it really works in Unilever, because what would be the truth of the document or evidence?
It's the fact of the threat. You're not saying that the claim to infringement rights is well made. You're saying, all right, let's move on. Let's look then at Bradford and Bingley and Rashid.
No, hang on. Let's not move on, because I don't understand what you're saying. The fact that there had been a threat, the truth or not of that doesn't arise in that. There had been a threat or there hadn't.
Yeah,
when
well,
you
that's what Hoffman's saying.
Evidence of the threat.
So Lord Hoffman says, if you are looking to adduce that correspondence as evidence of the fact that there's been a threat, then you can do that. It's not WP.
Feels different though, doesn't it?
Two Court of Appeal decisions, I suggest on my thesis, very, very difficult to reconcile. Let's look at two House of Lords decisions, Rashid and Offalu. Joe, you're going to tell us all about this, aren't you?
Section 29(5) of the Limitation Act provides that where there's an acknowledgement of a liability, you can start limit. I mean, it's typically debt claims. It restarts the clock effectively for limitation, and that's what these cases are about. So, Bradford and Bingley and Rashid was a mortgage case. So, Bradford and Bingley was the mortgagor, defendant was the mortgagee. Default, possession proceedings. There's a sale of the property, but there's a residue still owing to Bradford and Bingley of about $15,000. So the defendant, Rashid, engages a legal advice centre who sent Bradford and Bingley two letters. One letter saying he can't afford to pay, but he will when he can. And then another letter saying he'll give you £500 in full and final settlement. Bradford and Bingley then sue for the debt, and they're met with a limitation defence, and they need to rely on those letters as being acknowledgements in order to bring the claim within time. And the first instance decision was you can't rely on them, they're without prejudice, inadmissible. Court of Appeal agreed. but the House of Lords overruled that and held that the letters were admissible for the purpose of Section 29(5). Now, the reasoning is different as between different law lords. So Lord Hope said that he thought that any admission should just be admissible, should fall outside the scope of the without prejudice rule, following a line of Scottish cases. Lord Hoffman said he didn't think that could be right. That wasn't consistent with English law. But he thought, and this ties in with his independent fact theory, he thought that if you're relying on the correspondence simply for the purpose of Section 29(5), so simply to establish that there had been an acknowledgement so that limitation could run from then that fell outside the scope of the without prejudice communication, because you're not relying on it for any issue of truth, you're just relying on it as an acknowledgement. But the majority of the law lords didn't accept that analysis. It was Lords Walker, Brown and Mance. They said that that's an unreal distinction. You can't possibly say, on the one hand, they've acknowledged the debt and so we can have time running for limitation, but that evidence isn't admissible to show that, in fact, the debt was owing because they acknowledged it. So they said the reason it was admissible was because the communications were on their face apparently open. They were to discuss payment of an admitted liability, not to negotiate about a disputed liability. And so that's why. And again, so that's not really an exception. That's just saying we don't even get into the territory of without prejudice communications. So that's Bradford and Bingley. The other House of Lords case on this point was Ofulu and Bossert, which was a claim about possession to property. So there were claimant landlords, defendants who were occupying premises without the landlord's permission. And there was a first set of possession proceedings where the occupiers were saying, we have an oral lease, so we should be allowed to keep these, to stay in these premises. And in the course of those proceedings, they wrote a letter, say, offering to buy the premises from the claimants, the landlords. But that it didn't materialise it wasn't accepted, so there was no deal. There was then a later action by the same claimants seeking possession, but this time round, the defendants said that they had title to the property already because of adverse possession, because they'd been there for 12 years with the requisite intention. And in those proceedings, they needed to rely on the letter of offer under Section 29(5) for limitation purposes. And the House of Lords said, no, you can't rely on it. And the reasoning in that case was really based on the policy behind the rule. They said claimants and defendants have to be able to rely on without prejudice communications in order to be able to negotiate. So there we are. I mean, there was a dissent in that case, Lord Scott. It was a 4-1 decision. But
I mean, these are who's to know where the law's going to be or where he's going. So the client says, you've got a claim, you're going to mediation. Client says, I might want to offer to get time to pay. What about if I offer to pay this claim at so much a month over so many years? Would that be covered by without prejudice? You say, well, it's very difficult. I mean, there's a lot to say, you know. It might not be. It might be an acknowledgement. It's policy-based,
right?
It might be independent fact theory. Who knows?
Yeah. It depends. When you say would it be privilege, I guess it depends for what purpose what you're worried about the other side's going to use it for, right? So I don't think if you do offer to pay, and in a way that will trigger time running, I don't think you can then try to hide behind the privilege to say you're time barred. But the offer to pay can't necessarily be relied upon as an admission of a liability to pay. And I think the two are consistent.
But the client's the whole point is the more complicated you make it, the more inhibited people feel about what they can and cannot say in the context when they should be uninhibited. That's my point.
But in acknowledgement cases, there are different policy issues in play, aren't there? Because the courts, they want creditors not to rush to bring proceedings if it can possibly be avoided.
Oh, look, there's always a good reason for all these cases. My point, it's death by 1,000 cuts. I mean, where's the independent fact theory after Offalu? Because that was discussed, wasn't it, in Offalu?
I mean, the minority in Offalu sounds like quite similar to Hoffman and Lindsay, but they were the minority.
Yeah, the independent fact theory is very difficult, isn't it? I mean, Bradford and Bingley and Rashid, the majority didn't go along with Lord Hoffman's analysis.
All right. Now, what about their mitigation? Because this is another exception that we have. Joe, there's been, I think, a recent decision on this. Yeah,
so there's a decision of KSSL and King, where there was a dispute about the admissibility of statements made in a mediation. And the dispute about admissibility was decided at the pre-trial review. A number of exceptions were relied on by the defendant, which was the party seeking to rely on the statements. One of them was mitigation. And so the argument went that the claim was a claim in bribery. And the claimant had a discussion rather with the alleged payer of the bribe. But the proceedings, KSSL and King, were against the alleged recipient of the bribe. And the recipient of the bribe said, you, the claimant, should have done a deal with the payer of the bribe. And I want to rely on things said in that discussion to show that you failed to mitigate your loss by failing to do a deal with that person. Now, the decision at the PTR was that the evidence did fall within the exception. Oddly, the decision at trial was that there is no duty to mitigate loss where you have joint tortfeasors by suing or agreeing a settlement with one rather than the other tortfeasor. So, I mean, there's a slight inconsistency there with the analysis, because by reference to the decision at trial, it could never have been an issue of mitigation. And so really, it ought never to have been admissible.
Now, I just interrupt here. We've had a comment from a viewer that says, well, because mediation's confidential, it doesn't really matter about without prejudice. I don't think that's an answer, because confidentiality is no bar to admissibility. I mean, all the time. You can
or say the same example, but it's not a formal mediation. It's a settlement meeting, right? Like a Motorola.
No, but the point is, a confidential discussion is always admissible.
Confidentiality can be, can't it? It can be a reason why the court can decline to order inspection of the document.
That's disclosure, that's discretion, but it's not a bar to admissibility.
No.
Yeah.
You can't get an injunction to stop somebody giving evidence.
Yeah.
Okay, so I don't think that is an answer. Joe, I mean, you're right that if you've got a disclosure application and documents are confidential, the court may exercise its discretion.
Well, and you can get an injunction to stop someone from deploying a document that's confidential.
But it's all very fact specific, isn't it?
Doesn't affect its admissibility.
No.
Well, I'm not sure that's right. I'm not sure that's right. I think it would affect its admissibility. If someone sought to adduce evidence in breach of an injunction, I think that would. Well, Joe,
if that's the case, I think every trial bundle I've had is packed full of confidential
documents that are in breach of an injunction.
You know what Paul's practice is like.
Anyway, look, let's not go there. Different point. I'm very clear that and there's law on this as well. Confidentiality is no bar to admissibility. But anyway, we disagree. Let's talk about, Emily, this recent case on unambiguous impropriety, Motorola and Hytera.
Yeah, so this is a January 2001 Court of Appeal decision.
2021.
Sorry.
Yes.
Gosh, time flies.
I know I got hauled up for saying 2009 was recent the other day, but it is actually recent. It's 2020.
Right, 2021.
Yeah.
So it's a post-judgment freezing order case. Motorola brought a claim in the US against Hytera, which is a Chinese company, for theft of trade secrets and source code, and it was all about digital radio. And
Which are walkie-talkies, digital radio.
I know, that's what I
It's
thought.
all about walkie-talkies.
Radio.
I can't believe they're worth so much money. Anyway, sorry, carry on.
Who knew? So 3 of Motorola's senior engineers went to Hytera. They went to work for Hytera. They'd taken confidential documents and source code. And Motorola said that those engineers used that to help Hytera develop their product. Now, Hytera didn't deny that, but they played down the significance of the information they'd got from Motorola and said, anyway, it's all time barred. Now, the jury in the US found for Motorola, and they awarded damages of $750 million US, so a pretty chunky judgment. And Motorola applied for a freezing injunction over here against 2 of Hytera's UK subsidiaries. So they went under Section 25 of the Civil Jurisdiction and Judgments Act for a freezing order in support of foreign proceedings. And one of the things you obviously have to show to get the freezing order under Section 25 is there's a risk of dissipation of assets if the order isn't granted. And Motorola sought to rely on something that had been said without prejudice settlement negotiations by the CFO of Hytera. And what he'd said was that if judgment was obtained in the US that was unacceptable to Hytera, Hytera would take steps to move its assets out of Western jurisdictions to limit Motorola's ability to enforce the judgment that they got in the US. And Motorola said, well, look, that clearly comes within the unambiguous impropriety exception, so we should be able to rely on what was said in those WP negotiations. So, Claudia, what did Mr. Justice Jacobs say about that?
Well, everyone accepted that their statements were prima facie protected by without prejudice privilege because they were made in settlement negotiations, and that there is an unambiguous impropriety exception to that. Lord Justice Jacobs noted that the allegations, whether or not these statements had been made, was a question of fact. This was an application for a freezing injunction. So he said it's the interlocutory stage. The court should therefore consider whether, if they had been made, this would amount to an unambiguous impropriety. And he said, if these statements were made, then it's hard to see how they're anything other than unambiguously improper statements, because you're threatening to deprive a judgment creditor of the fruits of his judgment. And so if you can prove it at trial, then you'd rely on it. And he said he was satisfied on the balance of probabilities. Oh, no, sorry, not satisfied on satisfied at what he saw as the interlocutory, the relevant test, which is that you've got a good arguable case that they were made, and so he granted the injunction.
Court of Appeal?
Yeah, and then Court of Appeal.
Agreed.
The leading judgment was Lord Justice Males and Lord Justice Rose and Lewis had agreed. They disagreed with Mr. Justice Jacobs. So on the first point about the standard, they said it's not good arguable case. You just have to decide the point. Is it unambiguous impropriety or not? And they said it wasn't unambiguous impropriety. I mean, they analysed the particular statements made and said what they were doing was something that they would be entitled. What they were saying, threatening to do, was something that they would be entitled to do, and so it wasn't unambiguously improper.
It was all very fact specific, wasn't it?
Well,
yeah, and it invariably is.
I mean, that's what you want.
So I don't think it's that they disagreed with the test necessarily. It's just they saw that the conduct was this sort of conduct that is commercially justified at these sort of hard fought negotiations. They're threatening to do something which they are entitled to do. And Jacobs disagreed with that. Mr. Justice Jacobs disagreed with that. But
just what you want, isn't it? When you're trying to form a view as to whether you can or cannot say something in a position statement, just what you want to know. Oh, it's all fact specific. So,
well, no, but yeah. So you would allow people to say whatever they want, Paul?
I would go back to Rush and Tompkins. I would obviously some of the Unilever exceptions are axiomatic, like proving the settlement agreement was entered into. But phrases like unambiguous impropriety, independent fact theory, all these things are just a recipe for disaster. I mean, look at Hytera. Let me just ask you this, make this point to you. as I read it, unless it's unambiguous that the statement was made, regardless of if it was made, it would be unambiguously improper. But if there's any doubt about whether the statement was made, therefore you can't bring it in. They say that. So all you have to do, you go in the mitigation, you say, right, I'm going to shoot you if you don't, either your brains or your signature on the settlement agreement. The other side says, it's terrible, we're going off telling the judge. You say, I didn't say that. I didn't say that. Prove it. I mean, where are we? Right, I've got a couple of questions, right? A couple of examples. See how we do on this. See if this is all easy. Okay, mediation. One party says to the other, if you don't settle, even if we lose, we will find another claim and we won't stop till you're bankrupt. Now,
that might be right. That might be true. They might have
unambiguously improper.
No. And why would you be trying? What would you be trying to rely on it for anyway?
Oh, cross-examination, credit, get a freezer. I don't know.
No, you're entitled to. If you have claims against them, then they can find them.
Well,
they're just threatening to do that, which they're entitled to do anyway. I don't think
they haven't got one. He says, "We'll find one."
Yeah, but
fine. He's got to find someone who'll put his name. He's got to sign a statement of truth on the pleading. He's not saying, "I will put myself in contempt of court by manufacturing a claim that doesn't exist." Kind of.
And cop the evidence. We won't stop. We won't stop until we make you bankrupt. In other words, even if we lose that one, we'll find another one. We won't stop.
If
you're allowed to do that, if you keep wronging people and I take the decision to keep suing you on every single one of your wrongs until you're bankrupt and so they no longer wrong me, then I'm entitled to do that. It would only be wrongful if I'm manufacturing claims.
That's why Claudia's got a general civil restraint order.
Emily, what do you think?
I think you don't fall under any kind of, you're quite entitled to say that sort of thing. I mean, if there's a problem with the litigation that's being brought, there are other ways in which you can address that. You can try and get orders to
like the civil restraint order, right?
All right, here's another one. All right, Party A, Emily will like this one because you like the Finken decision, don't you, Emily? Party A says your witness statement is wrong, you're going to lose. Party B says, I don't care what the statement says, I can find plenty of other witnesses who will say what needs to be said.
I think that depends on the circumstances. I mean, if it's common ground that there were no other people there, that carries with it the assertion that they're going to find false witnesses, I think that probably is unambiguously.
Yeah, so if Party B has, for example, admitted that the witness statement is wrong and said, but it doesn't matter because I will find people who will back me up, then you would be looking, Party A would be looking to rely on that as evidence that the witness statement was false. And I think I don't think it would be protected by privilege, because by threatening to get other witnesses who will corroborate a fiction, that's definitely unambiguous.
Party B says, what I was referring to was there are a lot of other ways that I could prove my case forensically, and I'd obviously have to get witnesses to help. They may not have been present at the meeting, but I want to get an expert to show this, that, and the other, or whatever. I mean, Emily?
It depends on the context, doesn't it?
Yeah,
it depends on the facts.
It depends on the context. I think the more concerning thing is if somebody admits in a mediation that what they've said in their witness statement is untrue, because you can't then try and go behind the without prejudice privilege to get that in.
Somebody's asked, how does the court decide unambiguous impropriety? They have a trial. No, the Court of Appeal in Hytera says, no, you don't.
Yeah.
I flagged that up.
Decide it.
Just decide it on the...
You just have to decide it. And if you can't decide it, because there's a conflict of evidence, then you err on the side of excluding the material, which is a step in the right direction. But I mean, Hytera on the whole transferring assets, it's very vague about that.
Well, I disagree with you, Paul. I don't think it's vague at all. When you look at the facts and what was being said, these two subsidiaries had got excess cash in this jurisdiction. By moving it out of the jurisdiction, they weren't going to do anything wrong.
Well, but Miss Justice Jacob thought it was... I mean, I was involved at first instance, although we dropped out. We offered voluntary undertakings. But I mean, Mr. Justice Jacob didn't take that view. He thought it was unambiguously improper. Anyway, my point is, it's all as clear as mud. And if you want to get the statement in, there's loads of ways you could argue it can come in. Now, I think we're out of time, everybody. I just want to say a word about the episodes coming up. So next week, we're looking at bankers, really interesting stuff next week, bankers' duties to protect their customers from fraud. We did quite a bit on QuinceCare because of the Singularis decision last year. And there's been a recent case, Philip and Barclays Bank, which has held, in my view, wrongly, that a bank does not have that sort of duty to an individual customer. It only applies to agent situations where the agent's going to misappropriate the principal's assets. And it's an interesting case because it's going to the Court of Appeal. The judge gave permission to go to the Court of Appeal. And interesting to see that. There's a lot of these cases out there at the moment where customers have been the victim of fraud and they sue the bank. And this case suggests that QuinceCare is far more limited. So we'll be looking at that next week. Can I encourage you to subscribe to the Quadrant Chambers YouTube channel? I know I say it every week, but you really must. If you're not subscribed already, just click the button and subscribe. You'll get notification of all the programs that Quadrant Chambers put out. It's not just Quadcast, all sorts of things.
And can I encourage those of you who disagree with Paul and think that he's wrong to write in and tell us? So if you have any observations on the WP rule in practice,
Claudia,
for next
you're
week,
off message.
then do write in and do comment.
You're off message. Right. That leaves it for me, I think, just to say thank you to Poonam, who sat in for Emily producing the show this week, and also to Ben Jacobs, Fisheye Productions. Thanks to the team, and see you all next time.